Welcome to this explainer on witness management. Look, since you're already familiar with the foundational structures of assembly courts and state juror assemblies, we're going to jump right in and zero in on the strict operational procedures required for handling witnesses. From the core functions of court officers to the rigorous protocols for securing evidence, understanding exactly how witnesses are managed is absolutely vital to ensuring due process. Let's get to it. Here's our roadmap for today. We're looking at the role of witnesses, identification and statements, credibility and corroboration, scheduling and testimony, documentation and records, and finally, best practices and a quick summary. Okay, part 1, the role of witnesses and preserving the facts.
So according to the sources, a witness is basically an individual who provides first-hand observation of an event, like a trespass, for example, and then attests to those facts through sworn testimony or a formal affidavit of truth. And this is absolutely essential. Why? Well, in a common law system, no single magistrate decides the facts, right? The magistrate simply points out facts of law. It's actually the jury, composed of the people, that acts as the sole tribunal authority. Because the jury has to reach an absolute agreement, they rely entirely on the concrete facts provided by first-hand witnesses. They literally can't do their job without them.
And this brilliantly illustrates why witnesses matter so much. The source material frequently cites a really foundational legal maxim which is rooted in biblical texts like Deuteronomy and Matthew. It dictates that at the mouth of 2 witnesses or at the mouth of 3 witnesses, a matter is established. So within the operational procedures of these courts, a single accuser just isn't going to cut it. You strictly need 2 or 3 witnesses to firmly establish any matter of fact before jury. Moving on to part 2, identification and statements, and how we actually gather this evidence. Now, you might be wondering, how do we know who is actually testifying? Witness identification has to be incredibly strict. You can't just have someone wander into a proceeding without their identity being verified beyond a shadow of a doubt. Identity is often verified via attested affidavits or even historical documentation, like a family Bible. Get this, in some instances, it might require up to 4 separate witnesses just to officially verify the identity of the person coming forward. And of course, all of this proper vetting must be fully documented by the assembly. Once we've got them identified, gathering statements follows a really strict 4-step process. First up, the observation of the trespass actually occurs. Second, a fact-gathering interview takes place to collect things like correspondence, pictures, or video. Third, those raw observations are drafted into a formal affidavit of truth. And finally, this document must be autographed right there in the physical presence of a state-of-state notary or an assembly recording secretary. It's a highly structured pipeline. Which brings us to part 3, credibility and corroboration, or evaluating the testimony. The jury is tasked with carefully weighing all this evidence. On one side, you have corroborating testimony. This aligns perfectly with that 2 to 3 witness what we just talked about, and it's the specific mechanism that allows a jury to reach absolute agreement. On the flip side, if you have conflicting testimony, or just an unsupported claim by a single individual, well, that completely fails to satisfy the burden of proof. The plaintiff absolutely must prove their case or the defendant is absolved. Simple as that. The sources also provide a really fascinating perspective on how credibility is philosophically measured within this framework. They explicitly state sacrifice is the measure of credibility. So what does that actually mean operationally? It means a witness must be willing to swear an oath on their commercial liability for the truth of their statements. If someone isn't willing to put themselves at risk to verify their claims, they essentially forfeit all right to claim authority in the courtroom. It really raises the stakes, doesn't it? Let's look at part 4, scheduling and testimony within the living court. When it comes to the actual logistics of testimony, the responsibility falls heavily on a court officer known as the bondsman. According to the texts, a good bondsman needs to be well-organized, patient, and honestly, an excellent communicator. They're responsible for keeping a highly accurate roster of all witnesses. They also secure the courtroom, whether that means locking physical doors or monitoring a digital courtroom like a Zoom call, to ensure only cleared identified participants are present. On top of that, they act as the sole point of contact for the jury, ensuring they have access to all that witness evidence. During a living court scenario, testimony follows a highly structured timeline. While the justice guides the process, the floor really belongs entirely to the participants. It kicks off with the claimant presenting recorded facts, followed immediately by their witness. Then, the sequence mirrors itself for the defense. The accused tells their side of the story, followed by their witness. After each of these stages, the justice facilitates clarifying questions from the jury. Only after this strict timeline is totally complete does the recording pause for jury deliberation.
Next up is Part 5, Documentation and Records. This is all about securing the facts.
The transition from the spoken word in the courtroom to sworn paperwork requires physical, undeniable documentation. You'll often see this marked by the distinct stamp of a public notary or a recording secretary. These elected officials hold a position of really high trust. Their physical seal officially affirms the political status, identity, and statements of the witnesses, which gives the documents the full force and effect of the public law. And working tirelessly behind the scenes, we have the record keepers managing this critical paper trail. Their responsibilities are super precise. They collect the witness affidavits and distribute exact copies to ensure complete transparency. Typically, one stamped copy goes to the juror, one is retained by the State Juror Assembly, and one is filed with the county recorder. They also maintain meticulous logs of all meeting minutes, ensuring there is a permanent, secure record of the due process proceedings.
Finally, Part 6, Best Practices and Summary to ensure due process.
There's a fascinating, but honestly vital, best practice found in the court scripts provided in the sources. Always ask questions, never make statements. Why is that? Well, because the very moment you make a statement or a claim in the courtroom, you legally bear the burden of proof. So the highly recommended strategy for preserving your position and making sure the opposing party has to prove their claims is to strictly use questions. It's a real game changer in practice.
A few other key best practices highlighted throughout the materials include always bringing multiple witnesses with you for support. Remember that 2 to 3 witness rule. It's also absolutely critical to rely on properly vetted and trained notaries to oversee these judgments. Administrators like the coroner and the bondsman are instructed to maintain calm, precise communication at all times. This ensures that due process is strictly followed at every single step of the investigation and the trial.
So let's wrap this all up. Effective witness management helps preserve facts, improve investigations, and support informed decision-making throughout the court process. Because ultimately, the entire weight of justice relies completely on the courage of individuals to step forward and speak the truth. So I'll leave you with this. The next time you observe an event, ask yourself, are you prepared to risk your own credibility to establish the facts? Thanks for joining me for this explainer, and we'll see you next time.